Welcome to Human Rights Asia Weekly Roundup. These are the stories for this week's special program on Indonesia. Indonesia votes. Coverage on the presidential election. Civil society groups meet in Jakarta to discuss anti-torture bill. The Asian Human Rights Commission reviews Indonesia's criminal justice system. Welcome to Human Rights Asia Weekly Roundup. I'm Jessica Fernando. Indonesians cast their vote on the 9th of July to elect the country's next president. Competing in the election are two candidates, Prabowo Subianto and Joko Widodo. Prabowo is a former general of the Indonesian Army Special Forces and is notorious for his responsibility in the abduction of student activists in 1998 and for his involvement in the human rights abuses in East Timor. His rival, Joko Widodo, is the former mayor of Solo in East Java and is currently a non-active governor in the country's capital, Jakarta. The Election Commission will only announce the official result of the election on the 22nd of July. Quick counts held by 5 institutions indicate a marginal victory for Joko Widodo by around 5%. At the same time, Prabowo and his vice presidential candidate Hatta Rajasa has also claimed victory in the election. Indonesians in Hong Kong cast their vote in the presidential election at the central lawn of Victoria Park on the 6th of July. Over 23,000 individuals turned up to vote in the polling station, and 12,000 others sent their ballots to the Overseas Election Committee. These numbers are higher than those seen in the previous legislative election, where only around 6,000 individuals voted. The votes in Hong Kong were counted on the 9th of July, with Joko Widodo taking 75% of the votes. The election at Victoria Park ended in turmoil after the Overseas Election Committee shut down the polling station at 5 p.m. At that time, hundreds of people were still waiting to cast the vote. Following the closure of the polling station, eligible voters, mainly Indonesian domestic workers in Hong Kong, held a protest, questioning the committee for allocating only 8 hours for the election, despite the large number of registered voters. The protest was also triggered by controversial remarks allegedly made by a government official who indicated that the polling station would only be reopened if the remaining voters voted for a particular presidential candidate. To learn more about the ballots cast in Hong Kong for the Indonesian presidential election, we spoke with Fahmi Panimbang of Asia Monitor Resource Center.
Lalu, hari Minggu, kami warga Indonesia yang ada di Hong Kong berkesempatan untuk melakukan pemilihan langsung presiden yang ini adalah perhelatan 5 tahunan. Dan itu dilaksanakan sejak jam 9 sampai jam 5:15. Tapi antrian itu sudah mencapai seribuan sejak pukul 7 pagi. Saya datang sekitar jam 8 kurang seperempat dan itu sudah banyak antrian. Mungkin antrian itu sudah ketika saya datang sudah mencapai lebih dari 500 calon pemilih. Nah, antusiasme warga untuk memilih kali ini sangat besar dan panitia mencatat bahwa pemilih pada pemilu kali ini mencapai 111.000 pemilih di Hong Kong ini. Tetapi akhir dari mereka yang datang ke TPS mencapai 23.000 lebih. Nah, ini 2 kali lipat lebih besar dibanding pemilu legislatif pada April yang lalu. Ini tidak terantisipasi oleh panitia sehingga memang dari pagi hingga akhir sore pukul 5 penyelenggaraan pemilu memang relatif kacau dan tidak tertib. Menurut pengamatan kami, tim relawan pemantau pemilu di Hong Kong, petugas PPLN kurang dan kurang mengantisipasi antusiasme para pemilih, sehingga sampai akhir pemilihan pada pukul 5 yang seharusnya lapangan Victoria Park itu sudah harus selesai. Panitia masih mengulurkan waktu hingga 15 menit dan antrian itu masih besar. Terjadi protes oleh warga, dan protes itu karena diduga ada oknum dari petugas dari Jakarta yang memanas-manasi dengan menyatakan bahwa kalau memilih capres tertentu maka TPS akan dibuka, kalau tidak memilih capres tertentu, kalau hanya memilih capres itu maka tidak akan dibuka. Ini yang memicu kericuhan di kampung TPS di Victoria Park. Kami termasuk saya berada di lokasi pada saat kericuhan, dan kami sudah mendaftar. Sedikitnya ada 133 mereka yang menuntut untuk memilih karena mereka belum sempat memilih, dan kami sedang melakukan pengaduan dan gugatan pertama-tama melalui panitia pengawas pemilu di Hong Kong, dan kami juga sudah meluncurkan kampanye online yang bisa nanti disebarkan untuk ditandatangani dan didukung petisi menuntut dimungkinkannya calon pemilih kita yang ada di Hong Kong yang tidak punya kesempatan karena keterbatasan waktu penyelenggaraan pemilu. Tapi keterbatasan waktu ini juga merupakan pelanggaran administratif karena jumlah TPS yang kurang, jumlah petugas yang kurang memadai. Jadi kami akan melakukan investigasi, melakukan pelaporan, melakukan pengaduan dan gugatan, baik di Hong Kong maupun di pusat di Jakarta.
The Asian Human Rights Commission and the Commission for the Disappeared and Victims of Violence, KontraS, held a meeting in Jakarta on the 1st of July to discuss the plan on drafting an anti-torture bill for Indonesia. The meeting was attended by several civil society organizations, including Padang Legal Aid Institute, the Institute for Criminal Justice Reform, Aris Pelangi, and APIC Legal Aid Institute. Also present at the meeting were representatives of the Indonesian Ministry for Foreign Affairs and the General Directorate for Human Rights. At the meeting, both civil society organizations and the representatives of the Indonesian government agreed that a separate anti-torture law was needed. The Indonesian government representatives claimed that the government has started the process of drafting the law and is seeking comments from Indonesian civil society organizations. The meeting was held as part of the Asian Human Rights Commission's series of activities to commemorate the International Day in support of victims of torture on the 26th of June. Indonesia became free from dictatorship in 1998 after former President Suharto stepped down from office. Whereas many aspects of the system have subsequently changed for the better, this is not the case with the country's criminal justice system. Today, the penal code inherited from the Dutch colonial government in the 19th century, as well as the Code of Criminal Procedure enacted during Suharto's regime, are still maintained and applied. Despite reforms made by the country after 1998, judicial independence is still lacking. To learn more, we turn to Basil Fernando and Ansa Stianes of the Asian Human Rights Commission.
So the criminal justice system in Indonesia is pretty much based under outdated laws that we inherited from the past. Like for instance, we have this penal code, which we inherited from the Dutch government, and it was enacted in 1886, and we never changed it since then. And because the law was made by the colonial government, so many of the provisions actually aimed at securing the power of the ruler at the time, even though it's at the cost of violating freedom of expression and human rights, for instance. So then we also have this criminal procedure code, which was enacted under the dictatorship regime of Suharto. And basically the code gives so much space for human rights violations to take place, for unfair trials to take place. Like for instance, we have this provision where allows the police to detain an individual for up to 90 days without any intervention from the judiciary.
See, the question that anybody may ask if they don't know about Indonesia is, why is it that now after Suharto's period there's a period of 18 years and that period is called a period of reforms, that despite of that this 90-day period of keeping a person in custody without any access to the judiciary still exists. Now that is a very abnormal law compared to even worse places.
Well, I think there are several factors. I think some law enforcement officials and some law government officials genuinely believe that the long period of extension is necessary. Like if you talk to a common police officer, if you tell them that this is violating human rights and it's not necessary, they will ask you back like, how will we do the investigation? How do we make sure that this person doesn't escape? So there, at some point it's also lack of knowledge and poor investigation skills as well at the police. But also, on the other hand, I think at the same time there are police officers and mainly police officers who see the opportunity to make money of this long period of detention. Because basically when you have long period of detention, then it gives space for torture, because the torture marks will go away after 90 days. So then they're free to torture. And basically many police officers use torture as a mean to gain money. So they say they tell the detainees that unless you give us bribe or money, then we're going to torture you. So they don't want to have this, huge power be taken away from them. And for this very reason, I think the police have been the institution who gives so much resistance to the plan of the government and the parliament to amend the law and to basically allow judicial intervention, in the early stage of detention.
Yeah. See, that is where exactly the question is. The question is, who is more powerful? Is it the courts that are more powerful than the police, or the police more powerful than the courts? Now that balance, in a democracy, it is establishing the power of the court or the police or any other law enforcement authority that makes it possible to bring in the idea of the protection of individual rights. So why is that question of the importance of courts interfering with the police not being brought forth,
Yeah, I absolutely agree with you that under the current system, it's still the police who still has the main power. And you see, people mistake independence of judiciary, and people mistakenly understood separation of power in Indonesia. Like when they talk about independence of judiciary and that the legislative, executive, and judiciary should be separated, they think that the judges shouldn't have any intervention on investigation and things like that.
So that is a fundamental defect.
Yeah.
In the system, there is a fundamental defect. So long as this defect is there, you cannot come anywhere near to the international standards.
Sure.
So that's the issue that I think should concern the civil society. Because after all, 18 years of reform is a long period.
It is.
That is all for this week's Human Rights Asia Weekly Roundup. For more information, log on to www.humanrights.asia. Thank you for tuning in, and see you next week.